Hello friends, welcome to Inside Psychian Initiative. In today's video, we are going to discuss about Bilkis Bano case. You know that it made headlines in all the newspapers for last 24 hours. In this Bilkis Bano case, Supreme Court ordered that whoever the convicted people, previously, and they were released actually on the basis of remission grounds, and they have to be surrendered before the court within 2 weeks. That was the order given by the Supreme Court. And while giving this order, Supreme Court also mentioned that here in this particular case, Gujarat government is not competent to give remissions because all the trial as well as sentence given by the Maharashtra High Court, that means Bombay High Court. So, Gujarat government, Gujarat executive organ, they don't have any powers to give the remission. That is a summary of the judgment given by the Supreme Court. Of course, there are many things to discuss in this particular video. First, we will see the video components, then the syllabus mapping. So, in this video, we are going to discuss about why it is in news. This particular topic, I already explained why it is in news. Then, Bilkis Bano case, the timeline of this case, we will discuss. Then, Article 161 of the Constitution. Actually, this article deals with the pardoning power of the governor. Then, tell me students, which article deals with the pardoning power of the president? Put your answer in the comment section. Then, process of the pardon. That means the executive process, what is the process and what are the various steps involved. Then whether the pardoning power of the president or governor, whether it comes under the judicial review or not. Then on what grounds the remission will be given and what are the guidelines to be followed while granting the remissions. Then we will discuss about the power of pardoning powers of the president as well as the governor, how they were interpreted in various judgments. And finally, we will discuss the conclusion. So, these are the video components we are going to cover. Next, syllabus mapping. This particular topic is related to General Studies Paper 2, that is Indian Constitution Features and Significant Provisions. Now, let us see first what are the observations of the Supreme Court. Supreme Court, these are the following observations from the live law thing. Gujarat government, it has no competence, that means it don't have any power to pass what? To pass remission orders of the accused in the Bilkis Bano case. This was the Supreme Court observations. Here, the highlighted one is Gujarat government has no competence. When they don't have any competence means they cannot give the orders regarding the remissions. Then, so the other observation by Supreme Court, the judgment of Supreme Court which was given in the 13th of May 2022. Actually, this judgment in this Supreme Court observed that if at all the convicts have to get the remission, that has to be given by the Gujarat government. So, in this judgment, Supreme Court observed that this judgment is a nullity. That means this judgment don't have any value because it was obtained, the judgment was obtained by playing fraud on the court. So, that means court was wrongly guided. Some facts were suppressed. That is what Supreme Court observed. Next, Supreme Court observed that whoever, all these 11 convicted people, they have to be surrendered before the authorities, before the court within how many weeks? Within 2 weeks, they have to go back to prison. Here the catch is, here the most important point is, after they going to prison, again they can apply for the remissions. Now, this time they have to apply to the Maharashtra government, but not Gujarat government. That is the catch you have to understand here. Now, let me explain the concepts. The concept is overall, it was a very unfortunate incident. This Bilkis Bano incident, it was happened in 2002. Bilkis Bano incident. In this incident, on that fateful day, this woman, at that time, she was pregnant woman, she was being raped and her family members were killed and their bodies were mutilated as well. After that, of course, there are various stages involved. Initially, she filed a case. Then police, they given the report that they did not find any conclusive evidence. Even they requested for the closure of the case, but it was not allowed by the court. So there were various stages involved. But overall, just I am giving a glimpse of this case, that overview, bird's eye view. In this Bilkis Bano case, initially the Bombay High Court, actually the case was shifted to Bombay. Bombay High Court they given the life imprisonment, life imprisonment, life imprisonment to convicts, life imprisonment to convicts. This you have to understand. Okay, these convicted people, okay, they approached, like they served in jail for around more than 14 years and they approached to the Supreme Court. They approached to the Supreme Court that after 14 years serving in jail, according to the Gujarat government remission policy, after serving in 14 years, they are entitled to apply for the remission. Okay, that is what they mentioned in the Supreme Court. Here they misled the Supreme Court. Actually, when they went to the Gujarat High Court already told them that you have to go to Bombay High Court, not the Gujarat High Court. But they suppressed that fact here. Okay, and Supreme Court. What the Supreme Court done? Supreme Court has ordered that. Okay, ordered that. So it has the government of Gujarat. It is the government of Gujarat has to take the decision, and Gujarat government has to take the decision by appointing one committee. Okay, by appointing one committee. This independent committee, based on this committee report, the Gujarat government has to take the decision. This committee given a report that these convicted people, they can be the convicted one. The convicted one, they can be awarded the remission. Remission means the reduction of the sentence, the reduction of the duration of the sentence. They can be remission. They can be subjected to remission. This is the committee. Based on this committee observation, Gujarat government, okay, Gujarat government granted remission to these people, granted remission to these convicts. Okay, now here the judgment was challenged, this action was challenged. The Gujarat government executive action was challenged. On what grounds? On the grounds that, number one, okay, does Gujarat government has competent enough, this is the first thing. And the second thing is, the nature of crime is very heinous crime. Okay, in very like grave and serious crimes, in very grave and serious crimes, can convicts get remission or not? Okay, because that is a very serious crime. In these kind of crimes, can convicts will get this kind of remission or not? Whether Gujarat government followed the previous guidelines issued by the Supreme Court in this process or not? These were the contention point here. Okay, these were observed by the Supreme Court, and Supreme Court ordered that these 11 convicted people, they have to go to prison because the due process of law not followed. Number one, does the Gujarat government has the competent enough? No. It has to be done by the Maharashtra government, because here it is not about where the crime occurred. Okay, it is about where the crime was trialed and where the sentence was awarded. Here the case was trialed and sentence was awarded in the Bombay. So the Maharashtra government is the competent one. This one was addressed. Second, in very grave and serious crimes, can convicts get the remissions? No. This is the observation of the Supreme Court. So these two observations in yesterday's judgment. Now let's see further details regarding this case. So Supreme Court on Monday, that is 8th January, okay. So 8th January 2024, it cancelled out the Gujarat government decision of granting remission to these 11 convicts in the case of Bilkis Bano's case in 2002 Gujarat riots. And Supreme Court observed that Gujarat government has no jurisdiction to entertain this kind of application, and these orders of the Gujarat governments are completely inappropriate. This was the observation by the Supreme Court. And Maharashtra jurisdiction, Supreme Court mentioned that it is a place where case trialed. It's a place where this, like offense, they were convicted. That government is the authority. That government is having the authority. Here, Maharashtra government is having the authority, but not the Gujarat government. That is the summary. The Bilkis Bano case. In 2008, the special CBI court in Mumbai, that court awarded life imprisonment to these 11 convicted people. After 15 years of sentence, they approached to Supreme Court for the release of the, for the premature release based on this, Gujarat government policy. Supreme Court directed the Gujarat government to look into the issue by appointing a committee. That committee recommended their release, and on the 15th August 2022, they were released by the Gujarat government after granting the remission. After that, Bilkis Bano approached to Supreme Court. She filed a writ petition that here the government misused her power, and this writ petition was filed in September 2022. And final verdict came on 8th January 2024, and the verdict you already know. Here, the pardon exercised by the Gujarat government, obviously state government is, the head of the state government is governor. So governor executes pardon power under Article 161, whereas president give the pardon power and gets the pardon power under Article 72. By using the Article 161, president can pardon, reprieve, respite, remission, and remit and commute the sentences. Generally, governor can exercise all this kind of pardoning power related to any crime which is convicted against the state law, but not the union law. That we have to understand. And in the pardoning process, whatever the advice given by the Council of Ministers, it is binding on the governor. Governor cannot use discretionary power. In fact, president also cannot use the discretionary power while they are exercising the pardoning power. Actually, pardoning consists of various steps. First, for example, pardon. If you take the example, pardon. Okay, pardon means here the nature of sentence. That means whether it is a simple imprisonment or rigorous imprisonment, it will be completely cancelled out. There is no imprisonment. And the duration of sentence, whether it may be the 10 years or 15 years or 80 years, whatever it may be, the duration is also will be affected. So his duration will be abolished, and the nature of sentence also will be abolished, and he is not convicted as well. That means his sentence as well as his conviction both will be taken out. That means he come back to the stage where he did not commit any crime. This is the pardon. Pardon means it will completely absolve that person from the crime. Next, commutation. Commutation means here only the nature of punishment will be affected. That means if the person sentenced with rigorous imprisonment, this rigorous imprisonment will be changed to simple imprisonment. Here the duration will not change. That you have to understand. Next, remission. Remission is the reverse one. Remission, here the nature of sentence will not be affected, only the duration of sentence will be affected. That means if the sentence is 8 years, then it will be reduced to 5 years. Only duration will be affected. Next, reprieve. Reprieve means generally it is like getting stay, especially in cases related to death penalty. Getting stay. That means the sentence, whatever the sentence given by the court, it will be temporarily stopped. Next, finally, respite. Respite. Here, the nature of the sentence as well as the period of the sentence will be reduced. In which condition? In a special condition, such as due to the disability of the prisoner, or it may be due to the mental special needs of that prisoner, or it may be due to the pregnancy of the prisoner. Because of these things, the duration as well as the nature of the sentence can be reduced. So these are the various powers can be exercised by both president as well as governor. Of course, there are some significant differences between the pardoning power of the president as well as the governor. We will check that one. Okay. So this particular thing already I explained to you, and you can refer the notes later. Next, the pardoning power. President can give pardon power in relation to even the punishment given by the military courts also. That kind of power cannot be exercised by the governor. And the other one is president can exercise the pardon power only in relation to the violations of union law, whereas governor give the pardon power in relation to the violation of the state laws. These are the major differences between the president as well as the governor. Next, what is the process? The process of the pardoning petition is about, okay, the person first, prisoner, whoever the prisoner, first he will file for the mercy petition. He will file for the mercy petition, and this mercy petition will be given to the president. Here you have to understand one thing, whoever is asking for this mercy, okay, he cannot directly so present before the president. Okay, they can only apply, they cannot directly represent their case. It is not like a court, okay, and president forward this to Union Home Ministry, whether this person can be given, like pardon or not. Home Ministry will send that report to State Home Ministry, State Home Ministry, and State Home Ministry, by following the guidelines issued by the president in various cases, by following the guidelines, State Home Ministry will give their opinion about this case. Then Union Ministry, that means Home Ministry or Council of Ministers or Cabinet, they will give advice to President, and whatever the advice given by the Cabinet to President, and this advice has to follow. That means advice given by Council of Ministers is binding, is what? Binding on the President. And one more thing here you have to understand, students, that is the decision taken by the President with respect to pardon, this can be challenged in the court, because it should not be arbitrarily. The fair process must be followed in this entire procedure. So that means pardoning power of the president as well as the governor, it can be challenged in the court. So this is the procedure. Already I explained the procedure of this pardon thing. Next, on grounds. On what grounds? By following what procedure this pardon will be executed? The state government, by using the authority under section 432 of the CRPC. Section 432 of the CRPC is allowing that state government can give the pardon, okay, of course subjected to this mechanism, state government can give the pardon. But here you have to understand, state government can give this remission only if that particular state high court is sentenced that person. If the sentence occur in the other state, then the state cannot give any remission. That is the case with the Gujarat government. Here these persons were trialed and they were sentenced in the Maharashtra by Bombay High Court, not Gujarat. So Gujarat government cannot exercise their powers under section 432 of the CRPC. Of course, now CRPC is being replaced by the new criminal law as well. Next, in the following judgments, for example, in the Kehar Singh versus Union of India and Maru Ram versus Union of India, in these two cases, Supreme Court clearly mentioned that pardoning cannot be claimed as a right of the prisoner. Okay, it is only the discretion power of the government. Sometimes the pardon power can be rejected as well. Of course, many number of times they cannot claim as a right. How many years they served? Okay, it cannot be claimed as a right. And in the Maru Ram versus Union of India, Supreme Court clarified that President has to follow whatever the decision given by the Cabinet Minister. That means President cannot go for the discretion. Same applies to Governor as well. In Lakshman Naskar versus Union of India, in this case, Supreme Court laid down the following guidelines to be followed in exercising the pardoning power by the state executive or the union executive. These are: number one, whether the offence committed by those individuals, whether it is heinous offence or not, whether that offence will affect the society or not. Next, whether there is any chance that if you give the remission to these people, whether there is any chance that the same people will do that kind of crime again or not. That has to be considered. Third one, whether those convicted people, whether they lost the potentiality to commit that crime or not. For example, due to some old age or due to some physical disability, those people may not commit the same crime again. That means they lost the potentiality to commit the same crime. If that is the case also, they can be pardoned. And the purpose, whether they reformed or not, if the purpose is served, then also they can be released. Especially this was followed in the Rajiv Gandhi convicts. They were being released, Perarivalan and other few people. Next, socio-economic conditions of these prisoners' family. By considering all these things, pardoning can be given. Next, power of pardoning various countries. In British, the pardon power lies with the royal prerogative of the king or like king or queen. American Constitution, president can give the pardon power. President can give the pardon, of course, and I mean with respect to any offense. It may be the state law or it may be the federal law. President has that kind of power. Canada. In Canada, these kind of pardon powers are exercised by the National Parole Board, which works under the Criminal Records Act. And what is the final thing is? The final thing is this kind of pardon power cannot be misused and they should be used in a very judicious manner. That is our conclusion. Next, yesterday's video question. Which of the following are common rivers between India and Bangladesh? Okay, these 1, 2, 4. These are the common rivers. Kaladan is related to India and Myanmar. It cannot be the answer. Next, today's video question. Today's video question is, which of the following is not matched correctly? Pick the wrong match. Mains question. The Constitution of India provides pardoning power to the executive, of course. Explain the pardoning powers of the president and discuss how the scope of this pardoning power of the president is wider than the pardoning power of the governor. That means this is about comparing the pardoning power of the president with governor. Now, as we reach to the end of this video, let us do quick revision. In this particular video, we discussed about the timeline of the case and the overall bird's eye view of the case and the procedure involved in the pardoning process. Then pardoning power of the president and governor, we compared both of them and what are the Supreme Court observations in this particular case and whether the pardon power comes under the judicial review or not. With respect to that, even we discussed about some landmark judgments as well. So this is the detailed analysis regarding the Supreme Court observations on Bilkis Bano case. Thanks for watching.